One country, four courts. Each one has a specific role in the criminal justice system, and picking the wrong one isn't just an inconvenience, it's a jurisdictional error. So let's map the whole system from the bottom up. Picture a ladder. At the very bottom sit the courts that deal with the vast majority of everyday criminal cases. As you climb, the cases get rarer, the stakes get higher, and the legal questions get more complex. We'll build this ladder rung by rung, starting at the ground floor. Let's start at the base of the ladder, the youth court. This is a specialist criminal court that deals exclusively with defendants aged 10 to 17. It's technically a branch of the magistrates' court, but it operates with specially trained magistrates and in private, meaning the public and press are generally excluded to protect the young defendant's identity. Sentencing in the youth court is geared heavily towards rehabilitation rather than punishment. The philosophy is that young people can be redirected before a criminal career takes hold. Serious cases, like murder, can still be sent up to the Crown Court, but the youth court handles the majority of youth offending. One rung up sits the magistrates' court, and this is the workhorse of the entire criminal justice system. Around 95% of all criminal cases in England and Wales begin and end here. The court is presided over either by a bench of 2 or 3 lay magistrates, volunteers with no formal legal qualification, supported by a legally qualified clerk, or by a single district judge who is a qualified lawyer. There is no jury in the magistrates' court. The magistrates themselves decide both guilt and sentence. The court handles 2 categories of offence: summary offences, which can only be tried here, things like most driving offences and minor assault, and either way offences, which can be tried here or in the Crown Court, such as theft or actual bodily harm. For either way offences, magistrates decide whether they have sufficient sentencing powers to deal with the case. If not, they send it up. Their sentencing powers are capped, generally 6 months imprisonment for a single offence, rising to 12 months where 2 or more either way offences are sentenced together. Moving up the ladder, we reach the Crown Court, the primary venue for serious criminal trials. The Crown Court sits in various locations across England and Wales, the most famous being the Central Criminal Court, better known as the Old Bailey in London. Here, trials are heard by a judge and a jury of 12 members of the public. The jury's job is to decide the facts, guilty or not guilty, while the judge rules on the law and, if there is a conviction, determines the sentence. The Crown Court deals with indictable-only offences, the most serious crimes such as murder, rape, and robbery, which must be tried here. It also receives either-way offences sent up from the magistrates' court. Critically, the Crown Court has unlimited sentencing powers. It can impose the mandatory life sentence for murder or any other sentence the law permits. Appeals from magistrates go to the Crown Court on fact and law. Appeals against Crown Court decisions go upward to the Court of Appeal. One step from the top sits the Court of Appeal Criminal Division. This court does not conduct fresh trials. Instead, it reviews decisions made by the Crown Court and asks whether a conviction is safe or whether a sentence is manifestly excessive or wrong in principle. The judges, Lord and Lady Justices of Appeal, are senior members of the judiciary. A defendant who believes their conviction was wrongful or that their sentence was too long can apply for leave to appeal. The Court of Appeal can quash a conviction, substitute a different verdict, reduce a sentence, or in some cases, where the prosecution appeals a lenient sentence, actually increase it. Its decisions form binding precedent for the Crown Court below. At the very top of the ladder sits the Supreme Court, the final court of appeal for the entire United Kingdom. In criminal matters, the Supreme Court only hears cases that raise a point of law of general public importance. It is extremely rare for a criminal case to reach this level. When one does, the whole country is paying attention. The Supreme Court replaced the Appellate Committee of the House of Lords in 2009, and its 12 justices, headed by the President of the Supreme Court, sit in Middlesex Guildhall on Parliament Square. Its decisions bind every court below it, and they cannot be appealed further within the domestic system. Note that, separately, defendants may apply to the European Court of Human Rights in Strasbourg once domestic remedies are exhausted, but that court is not part of the English court hierarchy. Here's your check. Zara is 19 years old and has been charged with robbery, an indictable-only offence. Which court must try her case? Is it A, the Magistrates' Court, B, the Youth Court, C, the Crown Court, or D, the Court of Appeal? The answer is C, the Crown Court. Robbery is an indictable-only offence, which means it can only be tried on indictment in the Crown Court. The Magistrates' Court has no jurisdiction to try it, and the Youth Court only covers defendants under 18. From the Youth Court handling young offenders, through the Magistrates dealing with 19 in every 20 cases, up to the Crown Court for serious trials, the Court of Appeal reviewing decisions, and the Supreme Court setting the law of the land. Each rung on this ladder has a precise, defined function. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.